Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Welcome to the last Immigration Review podcast episode until Halloween. Not so spooky either, some pretty good wins for non-citizens. You'll hear all about them in just a minute. I'd like to take this opportunity to welcome new podcast patron, Barbara Camacho, to the Immigration Review podcast family. Thank you so much for your new support, Barbara. The podcast cannot do it without you and without all its other patrons. I say it all the time, and so I'm positive that all the patrons know how grateful I am for their support and how I'm always available to speak about any of these immigration issues or anything on your mind. I really enjoy it, and I'm honored by your support and your outreach. Keep it up! And if you'd like to get involved, click on the Patreon link in the show notes. It helps me do what I do. This week, that doing includes 5 cases, 3 of which are very positive for non-citizens, and 1, well, kind of positive. Pretty good week. Here they are. Welcome to the show. First is Corpeno-Romero et al. V. Garland, published by the Ninth Circuit on October 23rd, 2024. This case is about a lot of things, including past persecution. Judge Callahan dissented. Miss Candelaria and her minor son are from El Salvador and fled to the United States in fear of the M18 gang, which I feel is the 18th Street gang, but the Ninth Circuit says M18, so I'm going to say it too. They brought an asylum claim in immigration court in 2019. All witnesses, including expert psychological witnesses, were deemed credible, and their testimony was uncontested by DHS, meaning that their, quote, statements must be taken as true, end quote, for Ninth Circuit petition for review purposes. So, Ms. Candelaria had 3 children with a man named Carlos, including Javi, the child who was involved in this petition for review. Carlos was married to another person and in 2010 was shot and killed by an M18 gang member who was extorting him after he stopped making payments to them. No small thing, these extortion issues in El Salvador, and of course Carlos is now dead, but query whether he would have been granted asylum in the United States if he had fled just before being murdered, at least under the asylum law and the decisions that I so often discuss on the podcast. Ms. Candelaria went with Carlos' sister to a police station to identify the killers. The sister later told Ms. Candelaria that M18 had demanded that the family withdraw any report or else they'd be killed. But they identified the men, and the men that they identified were convicted and sentenced to long prison terms. But they were released not so long afterwards, considering 2018. Around that time, M18 began to harass Javi, then 14 years old. Eventually, they surrounded Javi and demanded that he join the gang or be killed. They also, quote, told him that they had already investigated and found out that he was the son of Chicharron, end quote, Carlos's nickname. They said they knew everything, using language against Javi that I will not repeat here. Javi and Miss Candelaria were terrified. Then men began to follow Miss Candelaria. and she recognized who they were. They were the men that she had identified all those years ago who had killed Carlos. Ms. Candelaria fled to her sister's home 5 hours north. Armed men then broke into the home that she had just fled afterwards. Ms. Candelaria and Javi fled to the United States. The immigration judge and the BIA believed that the harm wasn't bad enough to be past persecution and that in any event, it was just revenge or gang recruitment, not harm on account of race, religion, nationality, political opinion, or the particular social group of Ms. Candelaria or Javi as asylum would require. The Ninth Circuit majority disagreed. Heck, DHS didn't even cross-examine the psych experts who testified that Javi was suffering PTSD as a result of his experience in El Salvador. But we'll get there. To start off, there's an inter-circuit split in the Ninth Circuit about whether or not the court reviews a no past persecution finding de novo or for substantial evidence. Just flagging that, because that's a big deal, those different standards of review. The Ninth Circuit didn't address it here like other panels have not addressed it in the past, because it believed that the BIA's decision fell even under deferential substantial evidence review. For past persecution, hollow threats don't cut it. True, explained the court, but, quote, what matters in assessing the sufficiency of the threat to establish persecution is whether the group making the threat has the will or the ability to carry it out, end quote. And I mean, here they already killed the father, right? And they knew all about Javi. They surrounded him, threatened him, all that stuff. Then they broke into the house, armed. Quote, our case law does not require that a petitioner wait for the threat of violence to materialize before seeking the protections of asylum law, end quote. Jot that down. I'll wait. Or you can pause the show. Whatever you want. I'll never know anyway. In conclusion, the death threats were specific, menacing, and credible enough to the court. Past persecution in totality. That includes, again as well, expert psychological evidence that was not contested at all about the effect that all of this had had on Javi. Nice strategy, counsel. You'll love to see it. Quote, our cases have long recognized that emotional and psychological harm may constitute evidence of past persecution, end quote, explained the majority, responding to the dissent. Big quote here too, quote, because emotional trauma is a form of persecution. Evidence in support of such claim may be adduced, as was here, through witness testimony of the traumatic events in question, as well as expert testimony of its psychological after effects, end quote. Create your evidence, counsels. And now the floodgates are just open for favorable quotes in this decision. Quote, finally, the agency failed to consider Javi's experience from the perspective of his relatively young age. We have called age a critical factor in assessing persecution for teenagers older than Javi. And we have held that the agency commits legal error when it fails to measure the degree of their injuries by their impact on children of their ages, end quote. That's a big deal. Harm can be past persecution for children when it wouldn't be for adults. Lots of circuits now have similar precedent, as might even the BIA, by the way. Still all needs to be on account of a particular social group, at least in a case like this, to be past persecution, but the panel majority saw that too. Immediate family members of Carlos. Assumed a viable particular social group below, so it's just the on account of thing at issue here. To the court, the BIA failed to consider and properly analyze the possibility that this was a mixed motive case. M18 could be both out for revenge and targeting the family because of their relationship to Carlos, for example. Heck, just saying that out loud, it seems almost so close as to be materially meaningless, but that's just me. Similar with the gang recruitment. The gang might have targeted Javi because he was Carlos's son, at least one central reason. Quote, M18's efforts to track down Javi and then learn everything about him, and the fact that at least one of Carlos's convicted killers was involved in the gang's intimidation efforts and death threats, is powerful evidence that Javi's relationship to Carlos did not play a minor role and was not incidental, tangential, superficial, or subordinate to another reason for harm, end quote. More too. Turn your gang case into this one, quote, Javi's familial status caused the gang members to initiate their threats and remained front and center during his encounters with them, end quote. Don't let other precedent fool you, explained the panel, including that rough one on episode 163, Rodriguez and Nega v. Garland. So, remanded, with almost a straight up grant by the Ninth Circuit. But there's also still the government actor prong to qualify for asylum, and of course DHS should have the ability to meet its burden to rebut, right? And this is just me, but lots of the focus was on Javi in this one, who can't transmit an asylum grant, much less withholding of removal, to his mother. But why make issues where there are none identified by the majority? My bad. Judge Callahan agreed with the nexus stuff, but not on the past persecution stuff. Judge Callahan doesn't see harm that's bad enough to qualify as past persecution. By all means, congratulations Sean P. Perdomo and Mario Salgado for petitioners. And that is Corpeno-Romero et al. V. Garland. Before leaving the Ninth Circuit, I want to just touch on Otro, Lado et al. V. EOIR et al., published by the Ninth Circuit on October 23rd, 2024. I can't leave the circuit, after all, without summarizing this very complex and very long litigation victory achieved by non-citizen advocates this week. It's a litigation case, and it's exceptionally long, so here's the lowdown. In 2016, CBP at the border adopted a policy of metering asylum seekers at ports of entry, along the border between Mexico and the United States. Under that policy, whenever border officials deemed a port of entry to be at capacity, they turned away all people lacking valid travel documents. Many of those people intended to seek asylum in the United States, but were not allowed to even apply. They could try to come back some other time, but there was no guarantee that they would ever be processed. Well, the immigrant rights group Otro, Lado, and various other individuals and entities didn't like that and sued, and the district court ultimately declared the metering policy to be unlawful. The thing is, though, that while this litigation was ongoing, the government adopted a regulation known as the Asylum Transit Rule that many of you probably know all about, that generally required persons traveling through a third country to apply for asylum in that country before seeking asylum in the United States. For many asylum seekers who had already been turned away under the metering policy, this new asylum transit rule effectively barred them from qualifying for asylum if they were ever able to apply in the future, even though they would not have been barred or subjected to the rule if they had been processed that first time when they presented themselves at the port of entry but were turned away. Well, naturally then, as part of the remedy, the district court enjoined the government from applying the asylum transit rule to non-citizens turned away under the metering policy before the rule's adoption. The court also ordered the government to unwind past denials of asylum to such individuals. The government appealed, and here a split Ninth Circuit panel affirmed the district court's conclusion that the metering policy violated the Administrative Procedures Act and affirmed the grant of class-wide declaratory relief. Restated, the non-citizen entities and the non-citizens that they were advocating for won. I mean, there's a lot more to it, but there you go. Do some research to see how this might affect your client. See if they're a class member. All of it means, of course, congratulations to rockstar litigator Melissa E. Crow and the Center for Gender and Refugee Studies, and literally 2 pages of supporting attorneys and entities. Judge R. Nelson dissented, and the entire decision is 104 pages long, but there's the top line for your listening pleasure and further review. And that is Otro, Lado et al., the EOIR et al. Next up, Garcia Oliva v. Garland, published by the First Circuit on October 21st, 2024. Mr. Garcia Oliva is from Guatemala entered the United States on a tourist visa in 2000 and did not depart. He applied for asylum 18 years later, affirmatively. To be honest, he either got bad advice, did something bad, or had quite the strong claim to test that out. DHS initiated removal proceedings, where he eventually brought his claim in immigration court. Seems like USCIS did not decide his application or denied it, something like that, but DHS did initiate removal proceedings, and Mr. Garcia Oliva brought his asylum claim then in immigration court, with removal as the possible consequence should he fail. In his application and testimony, Mr. Garcia Oliva said that he only entered the United States one time, in 2000, and that his claim was based on his prior dangerous work as a bodyguard to a congressman in Guatemala. An IJ found Mr. Garcia Oliva not credible, in part because in his testimony, Mr. Garcia Oliva testified to multiple exits and re-entries into the United States, unlike in his application. Also, there appeared significant additions to his story in court as compared to what he had said in his application and sworn affidavit, as well as some discrepancies to the immigration judge. But also to the First Circuit, it calls these discrepancies and omissions glaring. The IJ relied on other holdings too, including a refusal to extend the 1-year deadline to file for asylum 17 years to make Mr. Garcia Oliva's Form I-589 timely. But the BIA affirmed only on adverse credibility and a finding that Mr. Garcia Oliva had not suffered past persecution, so that's what the First Circuit reviewed too. And it affirmed it. After all, quote, an adverse credibility determination appropriately reached may in itself suffice to defeat a non-citizen's claim for asylum, end quote. Not Convention Against Torture, but asylum, and in any event, almost always CAT, too. Credibility is a totality of the circumstances analysis, and here it was done sufficiently to the court. In addition to the discrepancies and omissions, the IJ also made a demeanor finding that Mr. Garcia Oliva lacked candor in his testimony, and those are hard to get reversed on appeal. Plus, quote, the weight that the IJ assigned to the petitioner's various explanations, including those regarding his use of false documentation, was reasonable, end quote. And the discrepancies were important to the First Circuit. In addition to the travel stuff, they included, quote, varying accounts regarding either the petitioner or a shop owner being approached by men, armed or not, and either being interrogated about the petitioner's whereabouts or being told to accompany the men, end quote. Restated, the discrepancies seemed important to Mr. Garcia Oliva's claims. But also, after the Real ID Act, discrepancies need not go to the heart of a claim to support an adverse credibility finding, although these ones sure seem like they might. And in any event, quote, the pervasiveness of the petitioner's inconsistencies could fairly lead a reasonable fact finder to conclude that he was an unreliable witness, end quote. Reasoned the court. Although maybe not required, the First Circuit went on to also address past persecution and Mr. Garcia Oliva's well-founded fear of future persecution and affirmed the BIA there too. Pretty quickly, kind of skimming the surface, the First Circuit clearly believes that the agency did an adequate job. Doesn't seem to really see a claim based on the group of, quote, former bodyguards, end quote, either. So, pretty quick denial. Unsure why it was published, but then again, I'm not aware of too much precedent out of the First Circuit on adverse credibility. And that is Garcia Oliva v. Garland. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. or of course, click on the link in the show notes. To the Sixth Circuit we come. Galvez-Bravo v. Garland, published by the 6th on October 23, 2024. This case is about hardship. Mr. Galvez-Bravo is from Mexico and has essentially lived and worked in Memphis, Tennessee for 30 years. He's never had authorization though, but then again he has 2 U.S. citizen children. He was placed in removal proceedings for reasons unexplained, and Mr. Galvez-Bravo applied for non-LPR cancellation of removal under INA Section 240A-B. That requires many elements to be shown, but the only one contested here is whether at least one of his U.S. citizen children would suffer exceptional and extremely unusual hardship upon his removal to Mexico. The IJ and the BIA said no. For reasons unexplained, Mr. Galvez-Bravo didn't actually petition for review that denial to the Sixth Circuit. Instead, he eventually moved to reopen his case with the BIA, explaining that now he had new and previously unavailable evidence that could satisfy the hardship standard. Namely, quote, his daughter's recent dyslexia diagnosis, a condition for which she was receiving support through her private school, end quote. If Mr. Galvez-Bravo had to go to Mexico, so the argument went, he'd lose his job, and his daughter could no longer get the special private school support that she needed. The BIA denied the motion, and that was petitioned for review to the Sixth Circuit. The Sixth Circuit affirmed. Not before a favorable ruling on jurisdiction, though. Remember, we're in post-Wilkinson world. Whether agreed-upon facts satisfy the non-LPR cancellation of removal legal standard is now and forever and always a mixed question of law and fact over which circuits have jurisdiction to review. But recall also, this is happening in the motion to reopen context. As such, Mr. Galvez-Bravo need only show that the new and previously unavailable evidence makes a prima facie showing that he is entitled to the relief sought. Does all that matter for jurisdiction and Wilkinson review purposes? It does not. Motion to reopen denials, where the non-citizen is claiming new eligibility for non-LPR cancellation of removal, appear reviewable in the Sixth Circuit. No small holding, so rock on in the Sixth. The court can review this issue because, for example, Mr. Galvez-Bravo, quote, does not ask us to question the board's finding as to the severity of his daughter's dyslexia or the nature of her current treatment, end quote. Just whether the agreed facts meet the non-LPR cancellation of removal standard, or I guess a prima facie showing standard, even lower. On to the merits then of the motion to reopen denial. Departing from recent precedent out of the Ninth and Fourth Circuits without mentioning matter of log, the panel explains that the merits review requires that the court, quote, ask whether Mr. Galvez-Bravo carried the heavy burden of showing that the BIA's decision was arbitrary, irrational, or contrary to law, end quote. To be fair, no mention of matter of Coelho either, or the matter of log versus matter of Coelho motion to reopen argument that's percolating amongst the circuits. That quote could also be read to really just be about how to challenge a motion to reopen denial at the circuit level. But still, don't forget that matter of log only requires a reasonable likelihood of success on the merits to succeed on a motion to reopen before the IJ or the BIA. Anyway, to show that the BIA must be reversed in its decision denying a motion to reopen, a non-citizen can make the showing in a few ways. That includes, for example, a showing that the BIA, without rational explanation, departed from prior established practice in deciding the issue. Remember that First Circuit case from episode 230, Bedos v. Garland? That kind of thing. Not met here, though, explained the court. To the Sixth Circuit, the BIA, quote, fairly articulated why the burdens expected to be experienced by Mr. Galvez-Bravo and his family, including a lower standard of living and diminished educational opportunities, did not satisfy the demanding, exceptional, and extremely unusual hardship standard, end quote. Didn't matter to the Sixth Circuit whether the children would accompany him to Mexico or not. The hardship analysis on the issue of insufficient educational support was the same and unmet to the Sixth Circuit. Nevertheless, and as I mentioned, Mr. Galvez-Bravo can still succeed on a bit of a procedural argument, that is, a showing that in its analysis the BIA departed from its prior decision-making arbitrarily. Quote, unexplained inconsistencies in the board's determinations regarding the same issue can support an abuse of discretion claim, end quote. That's a big holding in and of itself, and so indeed, very smart petition for review counsel, quote, points to several unpublished board decisions, reopening removal proceedings upon new evidence of a qualifying relative's learning disability, viewing such evidence as probative on the hardship question, end quote. Those unpublished BIA decisions are properly considered and reviewable, explained the Sixth Circuit, although less so, of course, than would be if they were precedential BIA decisions. But even so, the court saw no inconsistency or arbitrariness in how the BIA is deciding these cases. To the court reviewing those other unpublished decisions, quote, at most, they suggest the diagnosis of a particular learning disability can sometimes amount to a sufficient hardship. But given the unique factual record that underscores each determination, this fact alone does not suggest any obvious inconsistency in the board's approach here, end quote. So, a bit of a complicated argument that skirts around the merits a bit, but that is also what challenges to denials of motion to reopen at the circuit level sometimes require. The denial means that Mr. Galvez-Bravo lost his case, but it made some decent law for future non-citizens along the way in the Sixth Circuit. Cold comfort, I'm sure. And that is Galvez-Bravo v. Garland. Meaning we conclude with Francois v. Garland, published by the Fifth Circuit on October 24th, 2024. This is a withholding of removal and Convention Against Torture remand from the Fifth Circuit involving a Haitian citizen. Say what? Mr. Francois is from Haiti and came to the United States as a young man nearly 50 years ago to reunite with his father. He has 6 U.S. citizen children, 2 of whom are military veterans. But Mr. Francois also, quote, suffers from severe mental illness, including schizophrenia, psychotic disorder, and bipolar disorder. His symptoms include psychosis, delusions, engaging in self-talk, laughing to himself, and bizarre behavior such as drinking his own urine and eating grass, end quote. His mental health issues have led to multiple hospitalizations and crimes, and he's been found incompetent to stand trial in criminal court twice. And it all eventually landed him in removal proceedings, as apparently he's been here without authorization for a long time. I wonder if he could have gotten a parole in place through one of his veteran children, though. Hard enough to pursue as an attorney, but Mr. Francois, severely mentally ill as he was, initially defended himself in immigration court from detention pro se. Deemed incompetent, he did eventually obtain an attorney, and he applied for asylum and related relief and protection. As the basis, he identified the particular social group, Haitian nationals with chronic serious mental illness who exhibit perceptible symptoms of mental health that will require ongoing psychiatric treatment. Could you imagine identifying that group as a pro se litigant? His attorney submitted significant country condition evidence and a 48-page expert report. Indeed, apparently, and for your own similar cases, the expert, quote, explained that people in Haitian society see persons with mental illness as a discrete group, known as moun feu in Haitian Creole, roughly meaning crazy people. In Haitian society, moun feu implies a certain danger, and Haitian authorities often respond violently to moun feu behavior, end quote. Apologies for the mispronunciation, my Creole can be rusty. But, well, things like that are always very important in our ever-difficult quest to establish social distinction of a group in a society. Specific names for that group in the society that are bad are a great way to do it. The expert explained lots more things, too. And you know what? The IJ granted withholding of removal. Denied asylum is a matter of discretion, which is a pretty rare thing to do, and it seems that Mr. Francois was happy to take what he could get, but DHS was not and appealed. The BIA remanded, requiring more specific fact-finding. Neither party submitted anything on remand despite DHS getting what it wanted, but on remand the IJ reversed course and denied withholding of removal, finding that in fact Mr. Francois had not shown that he would be specifically, quote, targeted or singled out for persecution in Haiti based on his mental illness, end quote. Nor on remand did the IJ believe now that the horrible conditions previously found in Haiti's mental health facilities and prisons was done, quote, with the specific intent to inflict torture on criminal deportees or individuals suffering from mental illness, end quote. As the BIA seemed to indicate would be required in their remand order. More findings too made by the IJ on remand, and this time Mr. Francois appealed. Satisfied, the BIA affirmed. Based on the procedural history of the case, it appears possible that Mr. Francois was actually removed to Haiti during all of this litigation. But he has now won at the Fifth Circuit. Very, very smart arguments made by Mr. Francois, and the Fifth Circuit found exhausted, based pretty much on one sentence in the BIA brief below. So draft those BIA briefs intelligently, y'all. Anyway, to the Fifth Circuit, Mr. Francois argued that in its first remand, the BIA violated his due process rights because it, quote, ducked its clear error standard of review by remanding to the IJ for factual findings that the IJ had already made in violation of BIA regulations, end quote. Doesn't matter to the Fifth Circuit that the BIA said that it was reviewing the IJ's factual findings for clear error as the regulations require. What it did tells a different story, quote, the BIA is not entitled to state the correct legal standard, but actually apply an incorrect standard, end quote. To the Fifth Circuit, the IJ had already made factual findings on issues that the BIA remanded for factual findings on. That included a determination that, quote, Haitian authorities target the mentally ill with further harm, end quote, the mon fou stuff. And the IJ already found that the harm was beyond mere general abysmal prison conditions. And the IJ already found in that first decision that Mr. Francois himself would more likely than not be involuntarily institutionalized and then persecuted in such a facility. So when the BIA simply sent the matter back for further fact-finding on these issues, the BIA was violating the regulations and therefore Mr. Francois' due process rights. The BIA has to review facts already found under clear error review. It can't, quote, shirk its duty, end quote, and ignore what the IJ already found. And yet still, despite all of that, because it's immigration and because it's merely a regulatory violation, Mr. Francois cannot win and get a remand himself here unless he also shows, quote, substantial prejudice, end quote, as a result of the BIA's regulatory violation. That in turn requires, quote, a prima facie showing that the alleged violation affected the outcome of the proceedings, end quote. Easy case here, though, explained the Fifth Circuit. The BIA's shirking resulted in the IJ denying relief on remand that second time. So the Fifth Circuit vacated the BIA's second decision and remanded for it, the BIA, to consider the IJ's first decision as if nothing had ever happened afterwards. Wow. That's how you litigate. Too bad the Fifth Circuit doesn't list its attorneys in its day of decisions. But you know I've got the connections. Thanks to my UT Austin Conference co-panel, Jonathan Levy, I have learned that Maddie Dwertman of Baker Botts LLP, along with Priscilla Olivares, formerly of American Gateways and with them at the time of the litigation below, are responsible for this win. Along with amici briefs, or amicuses, from the Disability Rights Texas and Judge David L. Bazelon Center for Mental Health Law, and from the Roundtable of Former Immigration Judges. All deserve credit for this big win. I also came to learn that Mr. Francois was not in fact removed during all of this, but was released with the help of the organization RACES and others who brought federal court and public relations actions to support this human. Rock on. It truly takes a village, but my God, does it have to? And that is Francois v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.